Hi, this is David Bliven, Bronx and Westchester Divorce Attorney, with another episode of Lessons from the Divorce Wars. So this lesson comes in through, a few stories that I've heard recently about people's attorneys not having a client-centered approach. So the concept of a client-centered approach is something I learned way back in law school. And it really means you're putting the client first. You're not imposing your views or how you think the case should be resolved upon your client. You kind of pitch things neutrally and let them decide for themselves. In other words, it's their life, it's their kids, it's their money, and they should be captain of the ship. They should decide where the ship goes, and how things get resolved. A non-client-centered relationship would be where the attorney starts in with, well, I don't think you should agree to X, Y, Z. You'd be crazy to do stuff like that. It's different from giving your client legal advice and saying, well, hey, I just want you to be aware this is, what the law would give to you if you didn't settle or you took cases to trial or whatever. That's appropriate. But where it goes too far is where the attorney is really saying, well, this is what I would do if I were in your shoes. I get that question all the time from clients. And my response is, I'm not in your shoes. I don't live your life. So I'm not going to tell you what I would do if I were in your shoes, because to me, that's not a client-centered approach. That's not, putting the client first. It's actually putting me first. And I don't think that that's the role an attorney should play. Now, other attorneys disagree with that, and they'll actually go so far as I've heard these stories from other clients or potential clients where their attorneys will go to them and say, I won't let you settle for XYZ. And if you try and settle for things in that manner, I'm going to get off the case. I'm going to file an application. I'm just going to leave you as your attorney. To me, that's so inappropriate. It's not even funny. I can't even begin. It also doesn't mean that as an attorney, you shouldn't let your clients know of the consequences of their decisions. You should, absolutely. As but one of many, many examples that come to mind, let's say the two parties want to do a nesting situation. They get divorced, but they want to either continue living together under the same roof, just different parts of the house, or there's an agreement where, mom is in the house certain days or for a week or so, and then it flip-flops, and maybe they have another house to go to or something. You have to put in a provision into your settlement agreement, or at least you should, saying when that situation ends. In other words, when is there going to be a deadline under which your husband, if you're representing the wife, when your husband can no longer come to the house, when he needs to get his own place and not have access to the former marital residence? Now, maybe a client says, I'm okay with leaving it vague. I'm okay with leaving it open-ended. Okay, that's fine. I've let you know as an attorney, this is the recommended path. You should address that in your settlement agreement. And here's the consequence if you don't. If you don't put it in there, then it's going to leave a vagueness in your agreement, and it's going to be very, very hard for a judge to enforce that agreement and, in effect, force the husband out of the residence or enter an order saying the husband can no longer come, or the ex-husband in that case, because you left it intentionally vague. But as long as the attorney lets the client know this is what the potential is for that decision, these are the consequences, this is the weakness of agreeing to it in that manner, that's it. That's where your representation should stop. and then if the client says, yep, I hear what you're saying, that's the way I want it done, okay, fine, I'll draft the agreement. As long as, and I tend to memorialize those things in writing to the client, especially if I think they're making a bad decision. But it's their decision to make. And if you hire an attorney and the attorney is not taking a client-centered approach, and that's what you're more comfortable with, jump ship. Get another attorney. I actually had a recent incident where a client hired me because their prior attorney was being overly aggressive on a case that they just wanted to resolve in an amicable fashion. Well, you shouldn't have an attorney do that either. Your attorney should essentially do your bidding to a large degree, especially on issues of how the case settles and in what manner. You should never have an attorney just say, well, I'm going to be aggressive on every single thing, whether you like it or not as a client. Likewise, you shouldn't have the flip side where you want an attorney to be aggressive and the attorney says, well, I really just do a lot of mediation cases and uncontested cases. I don't really want to be aggressive. So, that's just not my style. Well, jump ship on that attorney as well, because any good attorney is going to be a chameleon. They change their colors to fit the case and what their client wants them to do. So they have the ability to be, nice, amicable, working out settlements, a mediation type attorney. But then if the case calls for it and the client wants them to pursue this path, they need to be a bulldog when the case calls for it and the client wants it. And if they can't change their colors like that to fit the case and fit what the client wants them to do, to me, they're not a good attorney. And they should not be representing that client. That client should go and hire another attorney. Okay? So that's another Lessons from the Divorce Wars. If you're looking for similar answers to like questions, check out my blog. You'll find it at blivenlaw.net/blog. See you next time.